All right, for this one, we're diving into the history books for a real courtroom drama from 1938. I'm talking big banks, a government on the move, and a law that had a pretty explosive secret hiding inside.
You know that feeling, right? You're reading the fine print and bam, there it is, a surprise fee you never saw coming. Now, what if that happened with an entire law? What if a law's title was just a cover for something else entirely?
So this is the heart of the whole mess. The law was called an act to reorganize the departments. Sounds pretty straightforward, right? Kind of boring even. But hidden deep inside was Section 11, and that section created a whole new tax, basically saying all the banks had to pay to fund the Bureau of Banking. You can bet the banks were not happy about that. This is the spark that lit the whole fire.
Okay, so here's how we're going to break it all down. First, we'll look at that sneaky hidden clause. Then, we'll dig into the one title rule, which is the key to this whole thing. We'll see what the court's majority thought, and then hear the powerful warning from the dissent. And of course, we'll get to the final verdict.
All right, first up, let's talk about this hidden clause. This is what kicked off the whole legal showdown.
And let me tell you, the players here were absolute heavyweights. You had the government on one side, and on the other, 9 major banks. We're talking huge names like HSBC and the National City Bank of New York. It was a classic standoff. The government said, pay up, and the banks said, no way.
So the government's argument was pretty simple, right? Look, we passed a law, Section 11 is in it, it says you have to pay. But for the banks, this wasn't really about the money. It was a matter of principle. They were making a huge claim that the entire law was unconstitutional because this tax was snuck into a bill about something else.
And that brings us to the legal heart of this entire case. It's called the one title rule. Think of it as a constitutional shield designed to stop lawmakers from playing these kinds of sneaky games.
This is it. This is the rule everything depended on. It came from the Jones Law, which was the Constitution back then, and it's so clear. It says a bill can only be about one subject, and that subject has to be right there, spelled out in the title. No surprises.
And why does this rule even exist? Well, it's there to prevent 3 really bad things. First is something called log rolling. You know, sticking something unpopular into a bill everyone likes. The second is to prevent straight-up surprise or fraud on the public and other lawmakers. And third, it's all about transparency. People should know what they're voting on, plain and simple.
Okay, so the rule seems pretty black and white. But how did the Supreme Court see it? Let's start with the majority opinion, which was led by Justice Abad Santos.
And this quote right here, it really sums up their entire way of thinking. They basically said, hey, let's not get so hung up on the tiny details that we stop the government from actually governing. They were arguing for a more, let's say, reasonable approach.
For them, the main point was this. The title of a law isn't supposed to be an index or a table of contents. It just has to be a general umbrella. As long as everything underneath that umbrella is related to the main point, it's okay.
So they came to this conclusion. Funding the Bureau of Banking is germane, and that's the key word here, germane, meaning relevant, to reorganizing the government. Their logic was, well, if you're reorganizing a government office, you also have to figure out how to pay for it. Makes sense, right? It's all connected.
But not everyone on the court was buying that argument, not by a long shot. And that brings us to the dissent from Justice Jose P. Laurel, who had a very different take on this whole thing.
For Justice Laurel, this wasn't some gray area. It was black and white. The title promised one thing, reorganization, but Section 11 did something completely different. It created a tax. To him, these were 2 different worlds.
And wow, he did not hold back in his dissent. This quote is famous for just how sharp and direct it is. He's basically saying, come on, everybody knows reorganizing and taxing are not the same thing. It's a simple, powerful point. And here's where it gets really interesting. Justice Laurel basically became a detective. He went through the legislative history and found what you could call a smoking gun. The original bill, the one that passed both the House and the Senate, didn't have this tax in it. It was slipped in at the very last second in a committee. For Laurel, this was proof positive that this was the exact kind of legislative trickery the rule was designed to stop. So let's just recap this amazing debate. On one side, you have the majority saying, let's be reasonable, funding is related, it's germane to organizing. On the other side, you have the dissent saying, absolutely not, to reorganize is not to tax. A title has to give fair warning, period. It's a fundamental disagreement about how laws should be made.
Okay, so after all that back and forth, who won? It's time for the final verdict. And the winner was the majority. It was a close call, but they won.
The Supreme Court said Section 11 was constitutional. The government got its way, and the banks had to open their wallets.
But wait, there's a little twist in the story. Even though the banks lost as a group, one of them actually got a pass, the National City Bank of New York. Why? Turns out, because it was technically an arm of the U.S. government, it was exempt from this local tax because of a different U.S. law. A little technical win for them, I guess.
So what's the big takeaway here? Well, the majority's decision set a new standard, allowing for a more flexible read of that one title rule. But Justice Laurel's dissent? It became legendary. It's still quoted today as this powerful, timeless warning about why we can't let our lawmakers hide things from us, even for the sake of convenience.
And that really leaves us with a huge question, one that's just as important now as it was back in 1938. Where is the line? When does a broad title just become a misleading one? It's something we still grapple with today, and it gets to the very heart of transparency in government.